Hello, I am Elda Lebenamar, and I hired Mr. Davis on October 2014. My granddaughter was removed from my home, and I was told that as a grandparent I had no rights, and that my granddaughter will soon be put on the list for adoption. She was put into foster care, and I heard of Mr. Davis. I researched and I hired him. The judge told Mr. Davis not once but twice to sit down while we were on the process of trying to talk to the judge. Mr. Davis did not take no for an answer.
Welcome, good morning. Welcome to CPS Office Hours. I'm Attorney Vince Davis. If you're approaching your 6-month review or a 6-month review, 6, 12, 18, or 24-month review, or even if you're not, today's live stream is your legal blueprint for those types of hearings. We're diving deep into how to win one of the most critical points in any CPS case, the 6-month review. I'm going to show you how to turn the tide, shift the judge's perspective, and legally force the court to consider returning your child home. Whether you're at the 6-month review or 3-month or 9-month, these strategies apply. If you're serious about protecting your rights, call my office now. All right, here's part 1. What is a 6-month review hearing? This is not just a check-in, it's a critical turning point in the case. The judge is looking for substantial progress in your court-ordered plans. The judge is looking for consistent participation in those services. The judge is looking for consistency in your visitation. The judge is also looking for whether CPS made reasonable efforts to give you services and to reunify you with your child. If you fall short, the court can continue the case for another 6-month hearing. The court can reduce your rights in the case. For example, take away your visitation rights or limit them. The court can even terminate some of your services if the court thinks that you're not serious and may take your visitation away. Legal anchor. Welfare and Institutions Code Section 366.21e is California's statute that governs the 6-month review hearing. If you're not in California and you have one of these cases, you will have a similar statute. They're mandated by federal regulations. So look in your state or talk to your attorney. What is your 6-month review statute? You should Google it. You should read it. You're going to be surprised when you read it because it's going to say things that you never knew. All right, part 2, a document-driven defense. The strategy is the court and the judge usually respects records, not stories. Create a 3-part document set. Number 1, the first part of your document should be proof of your participation in the case plan, your parenting, your domestic violence, your individual therapy, your substance abuse. Get your certificates, your attendance logs, your letters from providers. Number 2, get your visitation logs, the dates, the notes, the photos, the supervised visitation summaries. You can make those and you can get those through discovery from the social workers. You can also get letters from the visitation monitors. Sometimes those monitors are people that you picked. Sometimes those monitors are social workers. If they are social workers or social workers' assistants, believe me, there are records of those visitations. Get them through discovery from your attorney. And then the third type of documents you should be getting are your personal progress portfolio, your employment status or documents showing that you have a stable housing, your leases, your utility bills, and get supportive letters from friends, family, clergy, your employers, your mentors, your AA sponsor or your NA sponsor. Those all will help. It may later turn out that the judge may not accept them, but believe me, they may have just a little bit of persuasive authority. Here's a pro tip. File a supplemental declaration through your attorney 2 weeks before the hearing and include all of those documents. Make sure that you and your attorney give a copy of that declaration with all of those exhibits. You file it with the court and give a copy to every attorney. Part 3, challenging CPS's failures. The legal tool is to show CPS failed in their obligation to provide quote-unquote reasonable efforts. This is not a strong strategy in most cases, but in some cases it can be. Ask the social worker, did they make timely referrals? Ask yourself whether the services were accessible. For example, was it the right language? Did they pay for it? Was it in the right location? I recently had a case in Riverside where they wanted my client to do services right there in Riverside, California, but he lived in Arizona. Wrong location. Did they help with transportation for visitation? I don't know if you folks know this, but if they make if they place the child somewhere and it's a long way from you and you don't have transportation, they are obligated to provide transportation for you. And sometimes that's in terms of bus tokens, bus passes, and even gasoline if you have a car. What you may consider doing is filing a motion, a 388 motion, or filing a motion to compel or document the lack of reasonable services. In the 16,500, around there, a section of the Welfare and Institutions Code, and like sections throughout the United States in every state, there are statutes, laws that require social services and CPS to give you certain services and give them to you on a timely basis. Make sure that you and your attorney review those sections, discuss those, and make the appropriate motions when necessary. Part 4. You want to make sure that you and your attorney control the courtroom during your presentation of your case. Don't wait for CPS to tell your story or to minimize your story. Make sure that you're getting up on the stand. Make sure that you've submitted that written timeline and story of your case 2 weeks before. I mentioned that earlier. Ask your attorney to file those exhibits in that declaration early. Introduce your evidence as part of your compliance. Challenge CPS's negative recommendations. Courtroom language tip. Focus and say progress and safety. Those are the judge's key filters, and that is what the judge is thinking about. Remember, you want to persuade your audience. And in the courtroom, that's the jury. And in most states, you have no jury in CPS cases. Well, as Jerry Spence would say, you do have a jury. You have a jury of one, and that is the judge. Speak to your audience. All right, part 5. Reframe the narrative through witnesses, not through attorney argument, not through your attorney's argument, through witnesses that you bring in to court through by way of subpoena. Call people who've seen your transformation. This could be friends, family, could be your children, it could be your service providers, your drug counselor, your individual counselor, your domestic violence counselor, co-workers. Here are a list of witnesses that you should always consider. And always mention this to your court-appointed attorney. Parenting instructor, parenting instructors, therapists, employers, spiritual mentors. And if your attorney says, no, I don't think that's a good idea, make sure that your requests were in writing via email. And make sure that your attorney explains to you why that person would not be appropriate. Have each witness submit a signed letter or of support. File these letters prior to their testimony. The social worker's attorney may agree or stipulate that those letters come into evidence before the witness testifies. And a lot of times they may take that into consideration in changing their recommendation that the child not return home. Now, here's something I want to stress that a lot of people don't realize. At the 6-month hearing, if you're given unmonitored visits, but the recommendation is that the child not returned home, that recommendation is incongruent, meaning the test is that the social worker must prove by a preponderance of evidence that you're still a risk to the child. However, if the social worker agrees to give you unsupervised visits, by definition, that means you're not a risk. Therefore, if they recommend that you have unsupervised visits, in my opinion, by law, the child has to go home. Part 6, using the child's best interest standard. In California, and probably in most states, the judge must weigh whether return of the child is in the child's best interest. You and your attorney must argue the child is bonded to you. The placement is not as stable as your own home, and you have a support system for the child. Judges always like if other relatives are around or if grandma is living with you. They always feel safer if someone's around and supporting you and the child at home. It's not the only way to get the child, but it makes the judge more comfortable. Look into those alternatives. You and your attorney want to use phrases like, the child's emotional and developmental needs are best served by returning home. That's not a trick. That's probably true. And it's something that we all forget all too often. Part 7, how to build toward trial level proof. Remember, everything is not trial level evidence. Treat every hearing like this as a mini trial, because it is a mini trial. Submit evidence that is and exhibits that are admissible. Talk to your attorney, because not every piece of paper, not every exhibit, not every picture, not every video is admissible evidence. I often tell the story about the one guy who went to court and he took copies of the school records and copies of the medical records to the judge, and the judge wouldn't look at them. And he called the judge corrupt. And I asked him, I said, well, did you have the custodian of records in court to testify? No. Did you have a declaration from the custodian of records that said that these records were the true and correct copy? No. Well, the judge did the right thing. The judge didn't consider your evidence because you didn't lay the proper foundation for the records to become into evidence. What you had was inadmissible hearsay. Well, Mr. Davis, I didn't know that rule. And I reminded him of something that I learned during the first year of law school. Ignorance of the law is no excuse. May be unfair. I thought it was unfair, but that's the law. You're in this game, play by the rules. You want to make sure that you and your attorney are making objections to other people's evidence. You want to make sure that you and your attorney cross-examine CPS's witnesses, especially the social worker. I've said this many times. If you go to a trial or a hearing and the social worker introduces her report And all that happens is you and all the attorneys just argue. Nobody cross-examines any witnesses. Nobody puts in any other evidence. By definition, 99.9% of the time, you are going to lose because attorney argument is not evidence. And the only evidence the judge has is the CPS report. So by definition, the judge has to make a decision based upon the evidence. And the only evidence the judge has is the CPS report. So what does that mean? That means you lose. You must also consider and talk to your attorney that in some cases, you might want to hire an expert witness. You might want to hire an expert witness, for example, for parenting or trauma-informed therapy, maybe for substance abuse recovery. I've actually seen this happen where, my client had substance abuse problems, and the social worker opined, although not an expert, that my client needed more time in substance abuse recovery. And the judge, this particular judge I knew, would allow that testimony, even though the social worker wasn't an expert. So I brought in someone from the drug program who didn't charge us, who was an expert in drug abuse recovery, who testified and who qualified as an expert from her experience and her education, that in her opinion, my client had sufficient time in the program and had recovered. Recovery is an ongoing process, but would be safe with the child. So think about that. Part 8, filing your own motion before the hearing. Before the hearing, not at the hearing, consider filing a 3D8 motion. This triggers an evidentiary hearing by filing the motion to return your child. Force CPS to justify keeping the child in foster care. Now, I'm involved in a case right now up in Northern California, and we're right about the 3-month hearing. There was a disposition hearing. The child was placed out of the mother's home. And then the client hired me because she thought she was going to get the child back at the jurisdictional and dispositional hearing, and she didn't think she needed my help. And of course, she lost. Child's place remained in foster care. She then hires me. I look at the evidence, and she's doing all of her programs. So the first thing I do is I file, it's almost 150-page 388, okay? And the first thing that happens is within a week, the social worker writes an email to everyone and says, "Oh, I'm thinking, does anybody have any objection to the parent getting unmonitored visitation?" Unmonitored visitation? A couple months ago, you said you needed to have supervised visitation or monitored visitation, and it was dangerous. My client was dangerous to the child. So you see how you can file the 388 with the evidence, and it makes the social worker look kind of crazy when you present evidence to the judge and all the other attorneys that your client is actually doing very well in her participation in the services. Now, remember earlier I said at the 6-month hearing, if your client has unmonitored visitation, the child must return home? That was my humble interpretation of the law in California. Get it? Now my client has unmonitored visitation. So what's going to happen when my 388 hearing gets heard, or at the 6-month review hearing, which is in like 2 or 3 months? So you get it. You see how that works when you file that 388 petition. When you file a 388, you have to show changed circumstances, which is my client's ongoing participation in these programs and her visitation. And you have to show that the reunification is in the child's best interest. In this particular case, the child wants to return home and, is acting out. And basically, this child needs to return home. All right. Part 9, using the judge's language against CPS. You want to study previous orders made by the judge in this case. Find key phrases the judge uses: compliance, risk, stability. Echo those terms in your filings and in your oral arguments and in your presentation of evidence. Here's a strategic move. Make your filings and your evidence sound like the judge wrote it. Mimic the judge. Part 10. Contingency planning if the judge rules against you. If the judge doesn't return the child home at this 6-month review, ask for expanded visitation. Ask for a step-up reunification plan. Request the status review within 60 days, not 6 months. And consider your appeal strategy. File a notice of appeal immediately and consider writ relief if the hearing was procedurally unfair. Writ relief is really an emergency type of appeal. All right. If you have a 6-month, 12-month, or 18-month hearing coming up, or even if it already passed, this is your legal wake-up call. These hearings are where cases are either turned around or lost for good. If you need a strategist in your corner, please book a call with me for a consult. This is your moment. Make the court see who you really are. I'm Attorney Vince Davis. Let's win this together. All right, we have a few more minutes in today's office hours. What I'm going to do is I'm going to take some questions. I see the questions have been blowing up during the session, so let me go back and try to start from the beginning. Oh, let me change glasses. All right. All right, we have Betty Jo from YouTube. She says, what happens when you have an ICPC and they denied placement in the child with you because the GAL and the child's pediatrician, that is the best interest that she stay where she's at? Well, you're going to have a hearing, and you're going to have to present evidence to show that the child's GAL and the pediatrician are incorrect. That may require you to get an expert medical opinion to show why the pediatrician is incorrect, and to show that she could get like medical attention in the new placement in the new state. To be honest with you, it sounds, and I don't know anything about the case, that the pediatrician doesn't want to lose a patient. Is the pediatrician that much of a specialist that the child can't get like medical services, as good or better medical services in another state? Kind of doubt that, but who knows? Betty Jo also says from YouTube, the GL was taking the pediatrician's side after she already called me and asked me what was the best interest of the child. What do I think? I told her I think the best interest should be with family. Betty Jo, I really agree with you, but what you should do is you should find a doctor who can review the medical records and say, look, I can do just as good or better than the pediatrician that she has currently in her current home state. All right, Margaret King from YouTube. Good morning, Mr. Davis. I have a question. What is a foster parent's role to assist in the reunification process? In other words, how can a foster parent help the case? The foster parent should be encouraging visitation with the child and you, and not working against you. Unfortunately, in your county, Margaret, I've experienced where the foster parent actually works with the social worker to work against the parent. I don't know if that's all foster parents in your county, but I did a case maybe a couple of years ago where I thought that was actually happening, unfortunately. Margaret from YouTube says, can the foster parent be subpoenaed in the appeal? Not in the appeal, unfortunately, but the foster parent can be subpoenaed to the trial court. So when we go back to court, the foster parent can be subpoenaed. Neri Galindo from Facebook says, good morning. Good morning, Neri. How are you? Margaret says, 2 social workers stated they're working on getting the child home. Okay. I realize at times they say one thing and do another. How can I get them to put this in writing? You can't. You can't get them to put it in writing. And I'm not sure in your county I would believe them. Watch your back. Dorothy F. Cook from YouTube. What can I do if I was told I cannot speak until my daughter's adjudication court date by the judge and the court-appointed attorney assigned to the case before child was removed from custody? Dorothy, I'm not sure. You cannot speak to who? The child? And I'd find that very unusual. I'd have to know all of the circumstances. I have been on cases over the last 39 years where that kind of order might be appropriate, but I'd have to know more facts. In most cases, it wouldn't be appropriate. Okay, Lori Hillier from Facebook says, says William Mullins. Lori, I don't know what that means. Sorry. Dorothy says, unmonitored visitation, child can return home in California. Yes, Dorothy, in my opinion, because at the disposition hearing, they have to prove that you're a substantial danger. How could you be a substantial danger if they're giving you unmonitored visits, right? How could they leave you alone? And then at other hearings, subsequently, like 6-month review hearings, they have to prove that you're a risk. Well, if they're leaving you alone with the child, how could you be a risk, right? Even for 2 hours. If you were a risk, they wouldn't want to leave you with the child at all. Dorothy says, using judge's language against CPS. Yeah, that's what I said. From YouTube, Risen Rare Gem says, the bottom line is, if you can't afford a private attorney, you will just be roasted and your kids will end up adopted. Risen, I wouldn't say that, okay? There are some very good court-appointed attorneys. 30 years ago, I was a court-appointed attorney, okay? So I wouldn't come to that conclusion. Dorothy from from YouTube, make it sound like the judge wrote it. That's what I said. Dorothy, ask for expanded visitation. Dorothy, writ relief emergency appeal. Okay, Dorothy, you're taking notes, I see. Risen, if you decide to retain a lawyer, at least in Utah, the judge can order a public defender. Risen, if that's the law in Utah, I'd be really surprised, and that sounds almost unconstitutional. Check that with a private lawyer. I find that hard to believe, but I'm not saying you're wrong because I'm not a lawyer in Utah. Margaret King, your mother of the children is in a rehab in Mexico. Is it possible to get the case transferred there and the children placed with family closer to her? That's an interesting question. I've never had that issue come up. You can transfer through international placement. If the child, I've had cases transferred, but I never thought of that. I would have to research that, Margaret. I guess it is theoretically possible. I'm going to have to research that. Risen says, stay on the case as well. I'm not sure what you mean, Risen. Margaret, the mother of the child is in Mexico in a rehab. Can the case get transferred there and get the children closer to her? First thing, we have to show that her residence is now in Mexico. But I will take a look into that. Risen says, if you started out the case with a public defender, I'm not sure what you mean, Risen. Dorothy says, to the court judge when I was trying to defend my case. Margaret says, thank you, I appreciate you. Okay, that seems to be all of the questions. If there are not any more questions, that's the end of our office hours. And I'll see everyone tomorrow at 6:30 a.m. for our office hours. Stay safe. Have a good day.
On May 2016, like Mr. Davis promised, my granddaughter is home and I am in the process of adoption. I can only say it's a horrible nightmare. And if I did not have Mr. Davis pulling us through, it would have been another denial and my granddaughter would not have come home. I thank Mr. Davis from the bottom of my heart for taking my case. Thank you.